Hi everyone, and welcome back to episode 4 on Ireland's Magdalene Laundries. Today we dive deep into a story that goes beyond common misconception. We saw in the previous episode how the Irish courts sent women of all ages there. Today we'll uncover how, against all odds, children found themselves in the haunting world of the Magdalene Laundries. Picture this: innocent lives caught up in a system shaped by how Ireland's post-independence laws were used. It's a tale that's both shocking and eye-opening. So let's embark on this journey together as we uncover the lesser-known details behind Ireland's Magdalene Laundries. Ready? You're welcome to a drop in the ocean. And let's dive in. Ireland's Industrial and Reformatory Schools. These institutions were residential. They were meant to provide food, clothing and shelter to children. Industrial schools were designed for neglected, abandoned or orphaned children. Reformatory schools housed young offenders convicted of crimes. Both types of schools were intended to educate the children. However, in Ireland, the reality is far from what the description suggests. Survivors had been sharing their harrowing experiences for years, and after a decade-long inquiry, the official Ryan report in 2009 confirmed the horrifying and systemic abuses within these institutions. It's essential to note that these schools were primarily run by the Catholic Church, with funding and supervision from the state. Out of respect for the survivors and to delve deeper into this dark chapter of history, I will be dedicating an entire series to Ireland's industrial and reformatory schools on this channel. These schools were just one aspect of a broader pattern in our nation's history, often referred to as the architecture of containment, as accurately described by Professor Smith. Moreover, the impact of the laws in effect at the time extended beyond these schools. The report of the Interdepartmental Committee to establish the facts of state involvement with the Magdalene Laundries, or the McAleese Report, reveals that between 1922 and 1996, at least 28 laws in Ireland at the time were associated with sending children and vulnerable adults into the Magdalene Laundries, and or providing for their welfare while inside these institutions. To see how legislation was used to detain children and vulnerable people in Magdalene Laundries, commonly for generations, it's difficult to digest. The associated laws included lunacy and mental health laws, child welfare and education laws, employment and labour laws, criminal justice and offender laws, local government and social welfare laws. Then add in the Irish Catholic Church. Remember, Ireland was church-state ruled. The special position given to the Catholic Church in the Irish Constitution meant that there was little or no interference by the state into the institutions run by the Catholic Church, including industrial and reformatory schools and the Magdalene Laundries. The Children Act 1908 in Ireland was a significant piece of legislation concerning children, remaining almost unchanged for decades, actually almost a century. However, it was later amended and extended by Children Act 1941. It outlined several crucial aspects of child welfare and protection. It was a large document covering 92 pages containing 6 parts with 134 sections. I'll link the entire document below because I'm only going to be summarising some relevant sections here. Part 2 of the Act allowed for the arrest of individuals accused of mistreating or neglecting children. It also allowed the detention of a child or young person in a place of safety if they were believed to be a victim of an offence. The Gardaí, the Irish police, or any authorised person could take the child to such a place. A place of safety was defined as any suitable location, such as a workhouse, a police station, a hospital, surgery, or any other place willing to temporarily receive the child or young person. If a child or young person was placed in someone's care through this process, that caregiver had similar control over the child as if they were the parent. The law made it illegal for anyone to help a child run away from the person taking care of them, or to hide a child who had run away, or to interfere in the return of the child. The Act also granted the court the power to search for or remove a child suspected of being assaulted, ill-treated or neglected, or the victim of a relevant offence. Part 5 of the 1908 Act focused on young people who had committed crimes. The police had the responsibility to find places within or outside of their own district where these young offenders could be held, either by arranging with premises occupiers or establishing new ones. Children or young people could be detained until they were brought before a court. These places of detention were institutions other than prisons, funded publicly or by voluntary contributions. They could be used for remand or custody of children. The law expands the definition of a fit person to include not only individuals but also any society or body corporate. This means that in the context of providing care for children or young persons, a fit person can be an individual, a charitable society, or a corporate entity established for the reception or protection of poor children, or the prevention of cruelty to children. The School Attendance Act of 1926 mandated that children between the ages of 6 and 14 must attend school regularly. Parents were responsible for ensuring their children's regular school attendance, with some exceptions for legitimate reasons, like illness or if the child was engaged in light agricultural work at home. Parents were required to notify the school within 3 days if their child was absent. The Act also regulated child labour by setting limits on working hours and conditions to protect children. It established offences for individuals or employers who employed a child in violation of these regulations. Over the years, the law underwent changes. In 1926, it placed more emphasis on compulsory education. In 1972, the school leaving age was raised to 16. Amendments also strengthened protections against child labour, preventing children from being overworked. The Act included provisions related to detainment, places of safety, fit persons, and arrest of abusers. The Children Act 1908 played a significant role in the Magdalene Laundries saga. It was aimed at safeguarding children's welfare. It allowed for the arrest of parents or guardians accused of neglect or mistreatment. Children could be detained in places of safety without parental consent. The Act granted the caregivers parental authority over the children. Helping a child escape or hiding them was illegal. Places of safety could also be used for detaining children, again giving the caretaker parental rights. This law applied until the young person turned 21. They were under the legal custody of the caregiver. If they ran away, they could be brought back without a warrant. This sounds like a fair, safeguarding child welfare law. But this legislation was written by and for the United Kingdom. Ireland continued to use this Children's Act 1908. So in Ireland, fit person, place of safety, caregiver, related to Industrial and Reformatory Schools, Magdalene Laundries, and the religious institutions who ran them. This Act remained the primary legislation for children until the Child Care Act 1991. So for this section in the IDC report, it again acknowledges the lack of records, stating, "It is unclear whether departmental records of such recalls and placements in Magdalene Laundries were among those records lost or destroyed, or whether such notifications did not occur." When a child was sent to an industrial or reformatory school, they were required to remain there until a given age, but they were not then free. They remained under supervision by the school manager until the age of 18 or 19, up until 1941, and until the age of 21 following 1941. The IDC report, which looked at how children and young people ended up in Magdalene Laundries from these schools, found that admissions to Magdalene Laundries occurred in all the circumstances permitted by the legislation identified. This included girls temporarily placed in a Magdalene Laundry prior to committal to any industrial or reformatory school. However, as we'll see, if a girl had spent any time in a Magdalene Laundry, they could and would be refused admission to a reformatory school by the school manager. Girls committed by the courts to an industrial or reformatory school but refused entry to that school and admitted instead to a Magdalene Laundry. So the first reason here feeds the second one. Girls released on licence from industrial or reformatory schools to the Magdalene Laundries before the age of 16. Note there was no education provided in a Magdalene Laundry. Girls referred onward from an industrial or reformatory school to a Magdalene Laundry directly upon discharge at the age of 16. This appears to have happened quite a lot if a girl was raised in an industrial school, particularly if her mother was already in the Magdalene Laundry. Now, it could happen for other reasons, which we'll see a little later. Former industrial or reformatory school children referred to a Magdalene Laundry during the period of their post-discharge supervision. I must also add here that we now know for a fact that girls who were in some of the industrial schools and training schools, although registered in the school, would daily be transported into the Magdalene Laundry to work for no pay. This was never recorded anywhere, so it is not in the IDC report, although it has been acknowledged since. Release on licence. The Act permitted a child to be released on licence by the school manager to live with any trustworthy and respectable person who was willing to receive and take charge of him prior to the intended time of his discharge, ordinarily prior to the age of 16. So Magdalene Laundries were considered trustworthy and respectable. Children and young people would be released on licence to places other than Magdalene Laundries, commonly to a job, which would for girls generally be a maid or housekeeper, or could even be to allow them back home. But if the school manager thought the circumstances to be unfit, they would recall them or revoke the licence. Now remember, the schools were run by the same people as the Magdalene Laundries. If a child was under the age of 14, their release on licence was contingent upon their education being continued. Any duration spent on licence was considered a part of the child's detention period. If a child who was on licence ran away from the individual who was caring for them, they could be arrested without warrant and returned. So this just goes to show that although the legislation at the time led to confining girls and women in Magdalene Laundries, upon entry, no law applied. There was never education in a Magdalene Laundry. The school manager had the right to recall a child or young person at any time while they were on licence, possibly up until they were 21 years old. The child would be liable to recall if circumstances were not thought to be in the best interest of the child. While a child or young person was under supervision, their parents could not enforce their parental rights. From the IDC report, when a youthful offender or child is under the supervision of the manager of a certified school, it shall not be lawful for her parent to exercise, as respects the youthful offender or child, his rights and powers as parent, in such a manner as to interfere with the control of the manager over the youthful offender or child. Also from the IDC report, a person authorised by a school manager to bring a child to or from the school, or apprehending and bringing her back to the school in case of her escape or refusal to return, was granted all the powers, protection and privileges of a constable. And also from the IDC report, where a licence granted to a person under the supervision of the manager of a certified school is revoked, such person may be apprehended without warrant and brought back to the school. The IDC report also tells us that the committee found significant linkages between the schools and the Magdalene Laundries. It goes on to tell us that release on licence and recall during post-discharge supervision were the basis in many cases for women being placed in Magdalene Laundries, either directly from or within a number of years of their discharge from an industrial or reformatory school. We have some case files from the IDC report with the details of the girls who were put into Magdalene Laundries from industrial or reformatory schools. I'm going to present them exactly as recorded in the IDC report. The details given may leave you with more questions than answers about the children of Ireland in the Free State, but I feel we owe it to those children to acknowledge what little we do know about their time regarding the Magdalene Laundries. Again, from many records there are no exit dates, so we don't know if they ever got out. The IDC report says that anonymised case studies are included throughout this chapter to illustrate the types of circumstances in which referrals occurred. These case studies are taken both from official records identified by the committee among records of the Department of Education and Skills, and also from the records of the religious congregations which operated the Magdalene Laundries. So these first few case notes are under the heading Temporary Detention of a Girl Pending Transfer to Industrial or Reformatory School. A 13-year-old girl was brought by her mother to a Magdalene Laundry in the 1940s. After less than 2 weeks, she was sent to an industrial school, not on the site of a Magdalene Laundry. Her entry to the industrial school on that date is recorded in the files of the Department of Education. A 14-year-old girl was admitted to a Magdalene Laundry in the late 1950s. She was brought by a named ISPCC inspector. After approximately 2 weeks, she was taken by the same inspector to court and on to a named reformatory school. Her entry to reformatory school on that date is recorded in the files of the Department of Education. A 14-year-old girl whose parents were living outside the state was sent to a Magdalene Laundry by a named school, not an industrial school, in the 1970s. After a week, she was transferred to an industrial school on the site of a Magdalene Laundry. The next few are under the heading Refusal to Accept a Girl by an Industrial or Reformatory School. A 14-year-old girl was admitted to a Magdalene Laundry in the 1940s. She was brought by a named religious sister with a note on the register indicating that she had been committed for 3 years. She remained there for 2 years, after which she was sent to Kilmacud Reformatory. A 14-year-old girl whose mother was alive but her father was not known was brought to a Magdalene Laundry by a named ISPCC inspector in the 1960s. She remained there for 3 years exactly before being taken out by her aunt. A 15-year-old girl was brought by a named NSPCC inspector referred by a sergeant in the 1960s. After almost 2 years, she was sent to a named, unrelated woman. So this is where they would be sent to a job as a maid or a housekeeper. A 15-year-old girl was brought by an ISPCC inspector to a Magdalene laundry in the 1930s. She remained there for a year and a half before being transferred to another Magdalene laundry. A 12-year-old girl whose parents were deceased was sent by Dublin court in the late 1930s. She was sent for the school but could not be taken. She was instead admitted to a Magdalene laundry. She remained there for 2 years before being sent back to Dublin. A 13-year-old girl whose parents were not known was sent by Dublin court for the school in the 1940s. However, the register, which is unusually detailed in this case, records as follows. The child was in one of our Good Shepherd classes in England, so could not be taken in the school. This reference to a Good Shepherd class is to a Magdalene laundry in England. She was instead admitted to the Magdalene laundry on the same site. She became a consecrate 8 years after entry and in total remained there over 20 years. After which she transferred to another Magdalene laundry. She remained in the other Magdalene laundry for 4 years, after which she went to England. This is a clear example of what I mentioned earlier about girls being refused entry to an industrial or reformatory school, having spent any time in a Magdalene laundry. In these cases, they were liable to remain in the Magdalene laundry. This was not the only reason that they would be refused entry. It would also occur if the child was taught to be immoral. So if you remember in the previous episode, I read some excerpts from Girl in the Tunnel by Maureen Sullivan. Excellent book, I highly recommend. But Maureen would have been considered refused entry even though she never actually went to school. But she was sent to a school and instead ended up working in the laundry. And this would have been commonplace for abused children. Maureen was in no way guilty of committing anything immoral. Her stepfather was, but Maureen paid the price. Maureen was 11 and received no education thereafter. Because Maureen was working in the laundry and not actually attending classes, there were no records of Maureen. So how many other children did like happen to, and how many had no records? It was known at the time that there was no justice in sending girls to the Magdalene laundries, along with some other pieces of interesting observations, which I'll talk about. A memorandum written by a parole officer, Evelyn Carroll, dated the 7th of July 1941, observes that this action could lead to the refusal by a school manager to accept the girl into the school. It also observes that Magdalene laundries lacked provisions for girls, education just being one, and also that it couldn't really be expected that these girls should spend the rest of their lives within these institutions. Part of this memorandum was also shown in the IDC report, but you can find the full memorandum on the website probation.ie, the Irish Probation Journal 2014. But here's some of what Evelyn had to say. If a girl on remand is for any reason considered by the manager an undesirable type for the remand home, she may be sent, without waiting for official sanction, to the Magdalene Asylum attached, even though the girl is still a juvenile and perhaps awaiting trial of such offences as housebreaking, larceny, etc. Very often, these girls are subjects for the Reformatory School, St. Joseph's, Limerick. If and when they have been committed to the Reformatory School, the manager learns that they have spent even a week in Hyde Park, a Magdalene laundry. They are no longer considered suitable subjects for St. Joseph's, and they are immediately transferred to the Good Shepherd Convent adjoining, a Magdalene laundry. Scarcely a fair start for young girls under 16 who hitherto may not have had immoral tendencies. Evelyn goes on to say, Girls who have been brought up in industrial schools, and the same is true of most primary schools, and who not infrequently come before the courts on one charge or another, have often told the probation officer that they received no preparation whatever calculated to help them in the vital matters of sex. Neither did they get any instruction of a practical nature concerning courtship and marriage. Frequently they attribute their downfall to their lack of knowledge of these things. How far this neglect of essential moral training may be held responsible for our unmarried mother problem is worthy of serious consideration and investigation. In these homes, girls and women of all classes, ages and types work side by side. There is no minimum or maximum age limit, and one may find a girl still under 16 subject to the same regulation and doing the same type of work as the woman of 50 or 60 years, who has been through the world and has decided to give the remainder of her life to atone for her evil ways. Again, the educational facilities are absent, and the only training, in the physical sense, is the ordinary routine work of the institution, which always includes a public laundry, sewing, mending and cleaning. The supervision is strict, and the religious atmosphere and moral training provide a barrier against contamination not available in prison treatment. The religious training, however, is directed with the purpose of leading the subjects to a permanent renunciation of a world and to a life of penance in the particular institution, in accordance with its rules. All very laudable, but hardly appropriate for the type of girls undergoing a court sentence for a serious crime, seeing that with very rare exceptions, none such would dream of remaining on in a home voluntarily after the period of their detention has expired. Permanent renunciation of a world and to a life of penance in a particular institution, in accordance with its rules. This shows us entry to a Magdalene laundry purposely often did not include an exit date. They were not supposed to leave. The women held in Magdalene laundries, behind locked doors, high walls, locked gates, it seems were never meant to rejoin society. And this memorandum from a probation officer shows us that the state knew this. This memorandum was to the Archbishop of Dublin in the 1940s, subsequently forwarded to the Minister for Justice. But this injustice of sending girls and young women to Magdalene laundries continued, with no follow-up, no welfare checks. It continued. And remember, the last Magdalene laundry closed its doors in 1996. Another girl was committed to an industrial school in the 1940s. Her pupil file does not survive. The remaining records relating to her in the Department of Education indicated that she absconded from the industrial school at the age of 15. She was readmitted to the school the following day and immediately released on licence. The date of expiry of her period of detention occurred 3 months later. The departmental files indicate that this occurred while she was on licence to the Mistress of Penitence, Good Shepherd Home. The register of the relevant Magdalene laundry confirms her entry, although the date entered is the date of her running away from the industrial school rather than the following day. It is recorded that she was 16 years of age at her time of admission and that she was sent by a named person at her former industrial school. She remained in the Magdalene laundry for 5 months, at which point she was sent to another Magdalene laundry. So here's another case of no exit date. A different case identified in the department's archives related to a girl whose mother was dead and who was committed to industrial school at the age of 11 years. The department's file indicates that in the same month of her admission to the industrial school, she was released on licence to a named county home. After 1 day there, she was released on licence to a named Magdalene laundry. It is recorded that on the date of expiry of her period of detention 4 years later, she was still on licence to that Magdalene laundry. Her pupil file does not survive, and as a result, additional information is not available in the department's records. The register of the relevant Magdalene Laundry confirms her entry a few days after her release on licence, referred by a named person at her former industrial school. Her age is recorded as 12 years of age. She remained there almost 7 years, after which she was taken home by her father. Another case identified in the files of the Department of Education was that of a girl committed to an industrial school in the 1950s. Again, her pupil file does not survive. Less than 2 weeks after her admission to industrial school, the department's records indicate that she was unlicensed to Good Shepherd Home, Sundays Well, Cork, Magdalene Laundry. This transfer occurred a year before the date of expiry of the period for which she was committed to the industrial school. From the records of the religious congregation, she was 3 months in that Magdalene Laundry before she was sent to a different Magdalene Laundry, by permission of a named person. The named person in this regard was an inspector in the Department of Education, Industrial and Reformatory School branch. The department's files do not include any record of the circumstances in which this approval of the girl's transfer to another Magdalene Laundry was given. Similarly, the department's files include the case of a girl sent on licence from an industrial file during the 1960s to Good Shepherd Voluntary Home New Ross, again a Magdalene Laundry. She returned to the industrial school within a few months and was thereafter released on licence to her aunt. The department's files also include a case of a girl who had been committed at 2 years of age to an industrial school. She and her siblings had been committed to industrial schools after their mother deserted their father. The department's file indicates that she was on an unspecified date released, on licence to Sisters of Mercy, Galway, to train at laundry work. Yes, a Magdalene Laundry. As the full register of the relevant Magdalene Laundry has not survived, it is not possible to confirm the duration of her time at that institution. The next lot of case studies are under the heading Direct Transfer upon expiration of the period of detention in industrial school. A girl committed to an industrial school in the 1920s on the grounds of receiving alms. She was 14 years of age at the time. Her individual pupil file is one of those which cannot be found by the Department of Education and which is presumed to have been destroyed or thrown out. Her period of detention expired 2 years later. According to surviving records of the Department of Education, 8 days after that date, she was sent to Reverend Mother Good Shepherd Convent as a general servant, Magdalene Laundry. However, the register of the relevant Magdalene Laundry confirms that she entered that institution sent by the religious congregation which operated her former industrial school. The register notes that her parents were dead and that her siblings were living outside the state. She remained in the Magdalene Laundry for 10 years, at which point she was sent to a situation, a job. However, she returned to the Magdalene Laundry after 3 months and stayed another 2 years. Another case file identified in the files of the department relates to a girl who had been committed to an industrial school in the 1930s. On expiry of her period of detention in the 1940s, the file indicates that she was retained by the industrial school. A week later, she was sent to House of Refuge Dunleary. Her individual pupil file has not survived. As a result, further information is not available. And further, as the register of the Magdalene Laundry in Dunleary has not survived, it is not possible to confirm anything. The department's archives also include the details of a girl whose mother was dead, who had been committed to an industrial school at the age of 3 years. She remained in the industrial school until the expiry of her period of detention in the 1930s. According to the department's files, she was then, at the age of 16, sent to the Good Shepherd Home, Waterford, mentally deficient. Again, this is a Magdalene Laundry. The register of that Magdalene Laundry confirms this girl's admission at 16 years of age, having been sent by former industrial school. Otherwise, the register records only that she left in the same year as her admission. Another case in the Department of Education files, which refers specifically to laundry work, relates to a girl whose mother was dead and who was retained by her industrial school upon expiry of her period of detention. The file indicates that after retention she was sent to Reverend Mother St. Vincent's Convent, Cork, as a laundress, again a Magdalene Laundry. The register of the relevant Magdalene Laundry confirms her entry on the date during the 1950s, indicated in Department of Education files, and that she was 17 years old at the time. With the exception of 3 periods of hospitalisation for recorded reasons such as the removal of a cyst, she remained there until the closure of the Magdalene Laundry, after which she remained in the care of the congregations in sheltered accommodation until her death. Another case from the 1960s identified in the archives of the Department of Education relates to a girl discharged from an industrial school at the age of 13 to a named Magdalene Laundry. The register for the relevant Magdalene Laundry records that she remained there for over 2 years, at which point she was taken out by her mother. That brings us on to the last few case studies, and these are put in under the heading Recall during supervision following discharge from industrial or reformatory school. A girl discharged from an industrial school at 16 years of age in the 1960s. She was placed in employment as shop assistant. 2 weeks later, she was recalled and placed in alternative employment as domestic. She was again recalled 2 months later, and at this time placed in a named hospital, again as domestic. Her final recall was only 3 days later, following which she was sent to Good Shepherd Convent, Limerick. Again, no exit date. A girl committed to an industrial school in the 1950s was, on her discharge in the 1960s, placed in employment with a private person as mother's help. Her pupil file is not available, and as a result, further information is not available in the records of the department. However, the records of the religious congregation which operated the relevant Magdalene Laundry confirm that she was, approximately a year and a half after her discharge, sent to a Magdalene Laundry by the resident manager at her former industrial school. She remained there for almost 3 years, at which point she was taken out by her brother. The records of the department indicate that a girl discharged from an industrial school in the 1960s was sent to a named private individual in order to carry out domestic work. From the records of the religious congregation, the committee identified that 1 year later she was admitted to a Magdalene Laundry, having been referred by Mother Prioress at her former industrial school. She was 17 years of age at the time. After 6 months, she was sent to her mother. The department's files also include information on a girl who was committed to an industrial school at 6 years of age in the 1940s. She was placed in employment with a named private person on her discharge from the industrial school at age 16. She appears in the records of the Magdalene Laundry 1 year later, having been referred by the Mother Prioress at her former industrial school. She remained in the Magdalene Laundry for 4 years, at which point she was sent to a named psychiatric hospital. During the inquiry into state involvement with the Magdalene Laundries, as I've mentioned, Senator Martin McAleese did meet with some of the survivors of the Magdalene Laundries. He acknowledges in the report that when speaking to these women, as girls and young women, they were completely unaware that upon leaving school, they were subject to recall. They knew nothing about being unlicensed or being under supervision until 21. This was unknown. The IDC report states, none of these women were aware that a period of supervision followed their discharge from an industrial or reformatory school, or that they were liable to recall during that period. None of them recall being told this either at the time of their discharge from school or at any time during the supervision period. So, although Magdalene Laundries were considered places of safety and fit person, we know from the last episode they were also used by the courts for people convicted of crimes. We know that Gardaí had the power to arrest and bring people to the Magdalene Laundries, as did priests and nuns, as did the school managers, or anyone the school manager appointed. The girls and women inside the Magdalene Laundries would commonly get passed from one laundry to another. This was normally done at night time, under the cover of darkness. In the next episode, we're going to look at how vulnerable people ended up in the Magdalene Laundries, looking at public assistance authorities and institutions, health authorities, mother and baby homes, and psychiatric hospitals. I found this episode particularly difficult to research for, to see how poverty-stricken children and their parents in Ireland just didn't have a chance. Please let me know your thoughts in the comment section. And let's not forget, we have survivors with us today. This is not history. Again, there is no giving back to these people what was taken from them, but we can prevent recurrence. Thank you for joining me for this episode. It's a heavy topic, and I can't help but feel for the survivors. Let's continue the conversation in the comments. Click the thumbs up button, subscribe if you haven't already. Your support goes a long way in spreading awareness. Thank you, take care, good luck.